Hello, and welcome to Hofstra Law School's Video Viewpoints series. I'm Kristen McMahon. With me today is J. Scott Colesanti, Associate Professor of Legal Writing and an expert in business law and securities law. Welcome, Professor.
Hello.
President Obama recently signed into law sweeping reforms of the financial industry, the most we've seen since the Great Depression. Can you please explain it a bit for us, both the substance and the goals of the legislation?
Sure. I think the goals perhaps are the more interesting part of this, even though it is a 1,300-page bill. The goals in detail were to try and streamline government, put the weapons in the right place, to somehow prevent the internecine risk-taking that occurred in recent years, while at the same time making us competitive on a global scale, to somehow rein in Wall Street excesses while not choking off entrepreneurialism, and perhaps first and foremost to restore investor confidence. The stock market's no good if people think they're better off putting money in a bank or, God forbid, under their pillow. In terms of the substance, this Dodd-Frank Act is an amazing combination of so many targets and so many missiles, if you'll excuse the rough metaphor. On the one hand, it seeks to prevent the government from ever being again in that position that was in the fall of 2008, of having to get out the checkbook and essentially print money to create large titans to prop them up and keep them working on a daily basis. It also seeks to rein in products that had been previously exempted by prior Congresses and prior administrations. It also seeks to just do some things that flatly should have been done repeatedly that were not. And it tries to tie it all up in one pretty package that unfortunately became a monster in and of itself. It is both sophisticated and simple. At times it's exceedingly brief, at other times it's exceedingly complicated. And it has effective dates that range from the day the president signed it to 4 years or more going forward.
And how will these regulations impact the variety of constituencies that it seeks to address? Wall Street, the federal government, American constituents, and the like.
The federal government probably owns the onus of responsibilities right now. The Act itself creates 300 obligations in terms of rulemaking or federal studies. That means that the President and the Congress can now say, our work is done. They're going to appoint the heads of these agencies, and these agencies are going to have to get to work, and they are going to put teeth to these regulations, or in the worst case scenario, just grandstand and not put any teeth to these regulations. The Wall Street itself, I think they succeeded and they failed if their efforts were to stave off any type of reform. I think it's overly simplistic to think they won. I came of age in the legal profession in a world when there were banking regulators and there were securities regulators. And the two didn't mix much. And you could, like I did, become an expert in one without ever having to dabble in the other. Those days are gone. As an attorney and as a law student studying at Hofstra or elsewhere, if you have an affection for this thing known as business regulation, you're not going to have to master both of those methodologies, how we regulate banks and how we regulate broker-dealers.
And you mentioned too big to fail. Do you think that these new regulations will get rid of that idea, or do you think it might come back to haunt us in the future?
I think that's one, unfortunately, I know no one likes to hear this answer. It's too early to tell. I think the degree to which the agencies that now bear the responsibility of fleshing out these laws really try to rein in particular product lines will determine whether or not certain entities can continue the way they've been doing, or certain entities will have to say, now we don't want to grow that big, because once you grow that big, you have to engage in more government reporting, and you have to essentially, you're always a phone call away from numerous entities now, so it's just not worth it. Let's stay the size we're at.
So, but do you think that the legislation goes far enough in protecting us from future financial crises?
Protecting us from future financial crises, I guess I would have to break it down to the 4 types of evils that the American consumer has experienced in terms of home mortgages that were perhaps predatory, and what we collectively and quickly referred to as subprime debt. I think it's very interesting that we have an independent consumer protection agency now. I'm concerned that the carve-outs may have gutted the whole idea. A second ill, I would say, in all this is the securitization of these subprime mortgages, the gathering up of all individual home loans and creating a pretty package out of them, which Wall Street fell in love with in the years leading up to 2008. I think, yeah, that game is going to be much tougher to play. Thirdly, I would say, under the general notion of what we call faith in the stock market, I worked for many years at the stock exchange, and I'm personally disappointed that so little was done to reform the game itself. We continue to delegate the oversight of the nation's stock exchanges to the SEC and largely to the stock exchanges themselves. I think this is vastly ironic. If you were to make the crude comparison, if we look around and we say we're currently in a bad state of affairs because so many of us were in car accidents, we put so much emphasis on reforming cars and did nothing to the highways. Fourth and finally, I think there's a lot of feel-good. There are many feel-good issues out there, executive compensation, and the notion that certain products will never again hurt us, the fact that credit rating agencies will now no longer enjoy exemptions that have always been tied to First Amendment protections, and the fact that you can now sue a credit rating agency. I don't put a lot of stock in any of that. I don't think when push comes to shove, suing a credit rating agency will be a great business for any class action law firm. I'm not so sure that short selling is going to be seriously curtailed. I think the press may have made a little bit too much of those types of feel-good issues.
Also, many banks and other financial institutions lobbied against the legislation from the word go. Were any of the original proposals amended or taken out based on their objections?
Almost definitely. Let me say this. I still feel on the whole the piece of legislation was worthwhile. And although it was definitely the result of political compromise and both pro-regulation and pro-Wall Street forces are disappointed with it, I still think it's a plus. That being said, myself and a few others here on the Hofstra faculty were fortunate enough to be at President Obama's speech on April 22nd in Manhattan. And he outlined some very clear goals. He wanted, for example, for Wall Street to pay back some of the monies that were not going to be made up in the financial recoveries. The prior presidential administration put forth a piece of legislation that created what's known as TARP, the Troubled Asset Relief Program. That was $700 billion that went out the door. The Obama administration then followed up with another piece of legislation that essentially committed another $700 billion. So that's in excess of $1 trillion. Not all that money's coming back. What President Obama said in April of this year was, you know, that shortfall has to be made up by Wall Street. That didn't make it into the final bill.
And you've mentioned several agencies already. Who's ultimately in charge of making sure this law gets fully implemented?
That's an interesting point. I don't think it's accurate to say any one is. I think it goes by topic. If you were to create a crude scorecard of the Dodd-Frank Act, you'd see roughly 15 to 20 topics in order of decreasing significance. Near the top of that list, you would see the creation of a Financial Stability Oversight Council. And that's going to be staffed by 15 members that come from other governmental agencies. And I would put at the head of that scorecard the Federal Reserve and the Office of the Treasury, and the SEC has a seat there as well. In other areas, there are going to be specific tasks and perhaps quote-unquote lesser issues delegated to just one or two agencies. The SEC and the CFTC are going to have to work out when a product is subject to either or both of their jurisdictions, and really no one else in the government is going to have much of a say there. I think what's being lost in all this is how unique and uniquely vital our system of bureaucracy is. We hear bureaucracy and it's always a pejorative term, like, oh no, there's more people I have to call when my utilities bill is off. We have delegated the oversight of a mammoth securities market, really in the history of the world the most successful securities market, to a host of agencies. And we're now tweaking the rules a little bit, so hopefully they'll play better together and they'll play more efficiently.
And on the consumer side, how will creation of a new consumer protection agency actually impact American consumers?
The interesting thing I think about that agency is it's going to take so much of its philosophy from its first director. And that's the battle as we sit here today in August 2010 that is being fought. The name that's being bandied about is Elizabeth Warren, the Harvard professor who is such an outspoken advocate of reform and critic of the TARP program that she was put in charge of overseeing. The next big question is whether or not she gets nominated and whether or not she gets confirmed. If she is, I think that's a great first step for this Consumer Protection Agency. If, after working so hard to get this law passed, the administration backpedals and chooses what they feel is perhaps a more popular candidate, I think the Protection Agency is already starting out in a hole.
And how is the federal government planning to educate consumers about the new rules governing financial products, such as credit cards or mortgages?
I would have to say that's being largely delegated to the agencies themselves that have those responsibilities. If you want to learn the details of the Truth in Lending Act, you probably go to a HUD website. If you want to know how to file a complaint against your broker, you probably go to the websites of the SEC or in turn the self-regulatory organizations like the New York Stock Exchange. I don't see any tremendous independently funded government push to educate us all. And that, as an academic, is also a little alarming. There have been not many, but a few well-publicized studies in recent years that show the American consumer is woefully unprepared for financial transactions. A startling number don't know the rate of their own mortgage. The majority of people don't understand the interplay between inflation and interest rates. So I think you've hit upon something that is a real sore point there. It's all well and good even if the compromise bill succeeds on its compromise battlefield. How do we get people to understand there are these new avenues of redress? Again, I have to point to the bureaucracies. To give an example, hopefully a strong head of the Consumer Protection Agency takes over and then quickly educates people, or at least gives them the means of educating themselves and say, hey, we're another cop on the beat.
Well, Professor Colesanti, thank you so much for your time. For more information about Hofstra Law School, visit law.hofstra.edu.